Today, we're going to dive into the English legal system, which is pretty complex. It can be pretty daunting, especially if you're just starting out in law or maybe prepping for those QE exams. We're here to help break down the history, the structure, all the key players, and give you all the essentials. So let's start with the absolute basics. What is law? What's it all about? Well, at its core, law is basically a set of rules that we, as a society, agree to live by. And crucially, it's enforced by the state. So there are consequences if you don't follow the rules. Think of it as like the backbone of social order. Keeps things running smoothly. Makes sense. We hear this phrase common law thrown around a lot, especially when talking about the English legal system. What's that all about? How is that different from, say, civil law systems? That's a key difference. A lot of legal systems, especially in Europe and other parts of the world, rely primarily on written legal codes. Like, here the rules are all written down. We call that civil law. But English law is a bit different. It's built on what we call common law. And this means a lot of it comes from, decisions made by judges in past cases. It relies on building on previous rulings. It's like building a legal structure. But instead of bricks, we're using past cases, precedents. So judges are kind of like making the law with each decision. And it's something people debate about a lot. Okay. Some say that judges simply interpret the law as it is, but others argue that they actually have a role in shaping it. Those interpretations become part of the system. It's a fascinating balance between sticking to precedent and adapting to how society changes over time. Speaking of precedent, we should talk about this concept of binding precedent. Think of it like a chain of legal decisions. Each case is like a link in that chain. And what binding precedent means is that the lower courts, they're bound to follow decisions made by higher courts. So if a higher court ruled a certain way, a lower court has to follow suit. If it's a similar case, it's all about keeping the law consistent and predictable. Makes sense, but I imagine there are times when a judge might want to deviate from a precedent. That's where distinguishing comes in. It's a bit of a legal tactic. Imagine a judge is facing a case where there's a precedent that seems relevant, but they maybe don't want to follow it. Exactly what they might do is try to highlight subtle differences between this current case and the precedent, maybe in the facts of the case or the legal reasoning behind the previous ruling. So it's like saying, well, this case is a bit different, so that old ruling doesn't quite apply here. It's a way of kind of creating some flexibility within the system. There's also this whole hierarchy within the court system. We start with the magistrates' court. They handle less serious cases. Then we move up to the Crown Court. That's where more serious crimes are tried. And if you want to appeal a decision, we have the Court of Appeal. So it's getting more and more serious as we go up. And then right at the top, we have the Supreme Court. So it's like a legal pyramid with the Supreme Court at the peak. They sort out the most complex legal issues, keep everything consistent. And what about tribunals? Tribunals, they're a bit different. They're not part of that main court structure, but they're still really important. They handle specific types of disputes, often between individuals and the state. Things like immigration issues, employment disputes, that sort of thing. More specific areas of law. And they're designed to be a bit more accessible, a bit more efficient than the traditional courts. So we've got this structure, but who are the people that actually make this whole legal machine work? I'm talking about lawyers, of course, the essential cogs in the machine. So what's the difference between a solicitor and a barrister? I think a lot of people get confused by those terms. So basically, it's a division of labor. Your solicitors are your first point of contact. They give you legal advice, handle paperwork, prepare cases. So they're kind of like the general legal advisors. Then you've got barristers, and they're more the courtroom specialists. They're the ones who actually argue the cases before the judge. That's it. They're the ones who really know the ins and outs of courtroom procedure. All that. So solicitors handle the groundwork. Barristers are the courtroom stars. Though those lines are getting a bit blurred these days, you're getting more solicitor advocates now who can argue cases in court. Things are changing. It's an evolving landscape. Now, what about people who can't afford legal help? How does access to justice work, especially with all the changes to legal aid? That's a really important issue. Legal aid is basically financial assistance for people who can't afford to pay for a lawyer. But there have been a lot of cuts to legal aid recently, and that's made it much harder for people to get the legal help they need. So it's created a barrier for a lot of people. We're seeing more and more litigants in person, people who have to represent themselves in court because they can't afford a lawyer. That is incredibly challenging. Trying to navigate the legal system on your own is like trying to fix your car without any tools or knowledge. There are people pushing to simplify the system to provide more support for these litigants in person. Okay, so we've talked about the players, the structure. Now let's get into the substance of English law. What are the sources that make up this legal system? So we've got a few key sources. Firstly, we have statutes. These are laws passed by Parliament. So those are like the formal written rules. Then we have common law, which we've already talked about a bit, the precedent set by previous cases. And then we also have to consider the influence of European Union law and the European Convention on Human Rights. So it's not just a simple top-down system where Parliament sets all the rules. There's a lot of interplay between these different sources. Judges have to figure out how to interpret statutes in light of both domestic and international legal frameworks. So let's unpack some of those other sources a bit more. Starting with statutes. What's the deal, and how do they fit into the concept of parliamentary sovereignty? So as we said, statutes are the formal laws made by Parliament. They cover loads of content, from criminal law to environmental regulations. And they're basically the most authoritative source of law we have because Parliament is supreme. That's the idea, this concept of parliamentary sovereignty. It's like a cornerstone of the UK Constitution. It basically means that Parliament has the ultimate power to make, change, or get rid of any law. So they have the final say. In theory, yes. But in practice, it's not quite that simple. There are political limitations. Public opinion matters. There are also international obligations, and there's even the possibility of judicial review. So it's not a completely blank check for Parliament. They have to operate within certain boundaries. So it's not as straightforward as it might seem at first glance. The legal world rarely is simple. Now, we also mentioned the influence of European Union law, which is obviously a bit of a tricky topic these days. What exactly is EU law, and how has it impacted English law? EU law is basically a whole body of treaties and legislation that apply to all the EU member states. It covers loads of areas, from trade to consumer protection, environmental regulations, all sorts. And for quite a long time, it was basically like a supranational legal system, meaning it kind of sat alongside the English national legal system. They had this overarching authority. But then Brexit happened. That threw a bit of a spanner in the works. So the UK leaving the EU raised all sorts of questions about what happens to EU law in England and Wales because it was so intertwined with our legal system. Some EU law has been incorporated into UK law, but the exact relationship between the two is still kind of being worked out. So it's a bit of a transitional period, and a lot of legal scholars are watching this closely. It's a very dynamic situation. And what about the European Convention on Human Rights? Where does that fit in? The European Convention, it's a treaty that protects fundamental rights and freedoms. And while it's separate from EU law, it's actually been incorporated into English law through the Human Rights Act of 1998. So it's become part of our domestic law. And that means individuals in England can directly rely on the convention in legal cases. So it's added another layer of legal protection. It's not just about knowing the specific laws, but understanding how all these different sources of law interact and influence each other. That's the key to really grasping the complexity of the English legal system. I want to circle back to this idea of parliamentary sovereignty for a moment. You may still be trying to wrap your head around it. If Parliament is truly sovereign, shouldn't they be able to pass any law they want, even if it clashes with, say, EU law or the European Convention on Human Rights? This gets to the heart of a big debate in constitutional law. So the traditional view is that Parliament's power is absolute, no limits. They can make any law they want, no matter what. That's the theory anyway. But in reality, it's more complicated. Even if Parliament could technically pass laws that go against international obligations, there would likely be big political consequences. Other countries might object, for example, or international organizations, and courts might also try to interpret those laws in a way that fits with international commitments. So there are ways to try and reconcile those conflicts. There's always a bit of maneuvering going on. It's a balancing act, really. You could say that Parliament has this power, but it's not completely unlimited. It's a delicate dance between upholding parliamentary sovereignty and navigating those international legal waters. Okay, let's shift gears a bit and talk about the historical development of English law. I find this stuff really interesting because, unlike some countries that have these codified legal systems, ours has this long, winding history. So where does it all begin? Where can we trace the roots of English common law? This story really starts back in the 12th century with King Henry II. He established this system of royal courts. And those courts, they started developing a common set of legal principles that were used across the entire country. So it was a move away from the more localized, fragmented systems that existed before. It was about creating more unity, more consistency. These courts, they started hearing cases, making rulings based on what they saw as these common principles of justice. And those rulings became the precedents. That's it, the foundation of common law. So these early judges, they were basically shaping the entire legal system in a way. Pretty incredible to think about. It was a gradual process, with each case adding another layer to this growing body of law. But I imagine there were some bumps along the way. There were definitely some challenges. Because if you're just building on precedent, it could become a bit rigid, right? Sometimes applying the law so strictly could lead to unfair outcomes. And that's where equity comes into the picture. Equity. So we're not just talking about fairness in a general sense. This has a specific legal meaning. Equity developed as a separate system to address those situations where common law just didn't quite deliver justice, as a way to smooth out the rough edges. It was about ensuring fairness, even if it meant bending the strict rules of common law. Let us think of an example of how equity worked in practice. A classic example is the development of injunctions. An injunction is basically a court order that tells someone to either do something or stop doing something. It was a tool that the courts of equity developed, so it gave them a way to directly intervene and prevent harm. And although those courts of common law and equity were eventually merged, the principles of equity still have an impact on the legal system today. Judges still consider these principles when making decisions. So it's not just a historical footnote. Equity is woven into how the system operates. It is about ensuring fairness is at the heart of the process. I want to switch gears a bit and talk about the Constitution. Let us think about the British Constitution and how it relates to the English legal system. The British Constitution is a bit unique. Unlike many countries which have a single written document that outlines their constitution, the British Constitution is unwritten. Unwritten. So how do you even know what the rules are? It's like a big jigsaw puzzle. You have to put together all these different sources. You've got historical documents like the Magna Carta. You've got statutes passed by Parliament, common law principles, even conventions. Those are like unwritten rules and practices everyone just accepts as part of the constitutional framework. So it's this constantly evolving thing. It's adapting all the time. And that has its pros and cons. On the one hand, it's flexible. It can change with the times. But on the other hand, it can be a bit unclear, open to different interpretations. That's why you get so many debates about what the Constitution actually means. So, who gets to decide what it means? Well, that's where the courts come in. They have a big role in clarifying constitutional principles and resolving disputes about how the Constitution should be interpreted. So, judges have quite a bit of power in this area. It's one of the things that makes the English legal system so interesting, so dynamic. All right, so we know the British Constitution is unwritten and constantly evolving. But what are some of the core principles that hold this whole system together? One of the most important ones is parliamentary sovereignty. Okay, we've touched on that. It's this idea that Parliament is the ultimate lawmaking body in the UK. No one can overrule them. That's the principle. But remember, it's not totally absolute in practice. There are those political and practical limits we talked about. So Parliament is supreme, but within certain boundaries. So what other key principles are at play? There's also the separation of powers. This is the idea that government power shouldn't be concentrated in one place. It needs to be spread out, checks and balances, to prevent any one branch from getting too powerful. So how does that work in the UK system? We usually talk about three branches of government: the legislature, the executive, and the judiciary. The legislature makes the laws. That's Parliament. The executive implements the laws. That's the Prime Minister and the government. And then the judiciary, that's the courts and the judges. They interpret and apply the law. So everyone has their own lane, their own responsibilities, in theory. But it's not always that clear-cut in practice. There's some overlap. For example, the executive often initiates legislation, and judges sometimes have to make decisions that have policy implications. So the lines can get a bit blurry. But the principle of separation of powers, it's still really important. It's a framework for accountability. So we've got parliamentary sovereignty, we've got separation of powers. And then there's this other big idea that often comes up when talking about constitutional law, the rule of law. So the rule of law basically means that everyone is subject to the law. No one is above it, no special treatment for anyone. It means the laws should be clear, predictable, and applied fairly and consistently, so everyone knows what the rules are, and they can be confident that those rules will be applied fairly. That's the idea. The rule of law also includes things like access to justice, fair trial rights, and protection from arbitrary government actions. It's about protecting individuals. It's a fundamental safeguard against tyranny. It's a cornerstone of a free society. So we've got all these principles: the rule of law, access to justice, separation of powers. But who's ultimately responsible for upholding these principles? Who makes sure the legal system is actually functioning as it should? Well, that's a big part of the judiciary's role. The judges. They're the ones who have to make sure everything runs smoothly. They interpret and apply the law, ensure fair trials, and resolve disputes. So they're kind of like the referees of the legal system, making sure everyone's playing by the rules. And their decisions have a direct impact on people's lives, shaping how the law is understood and applied in everyday situations. And given that level of responsibility, impartiality, and independence are absolutely crucial for judges. So they can't be swayed by political pressure or personal biases. Judicial independence is a cornerstone of the English legal system. It's about making sure judges can make decisions based solely on the law and the facts of the case, without fear of any repercussions. Without judicial independence, there is a real risk that decisions could be compromised, and that undermines the whole idea of justice. It would erode public trust in the system. So how do we protect that independence? What safeguards are in place? One of the most important safeguards is security of tenure. This means that judges, especially those in the higher courts, have a guaranteed term of office. They can't be easily removed, so no one can just fire a judge because they don't like a particular ruling. Judges can only be removed in very specific circumstances. Usually, it involves serious misconduct. And even then, it requires the approval of Parliament. So there's a high bar for removing a judge, and that helps to insulate them from political pressure. It allows them to make decisions based on the law without worrying about losing their job. It's all about protecting that independence. In some countries, judges are elected. Is that how it works in England and Wales? No. English judges are appointed, not elected. So no campaigning for judge positions. It's all about finding the most qualified people for the job. That's the goal. The appointment process is really rigorous. It focuses on legal expertise, suitability for the role, things like that. So not a popularity contest, definitely not. And the whole point of this system is to safeguard judicial independence even further. It ensures that judges are chosen based on merit, not on political pressures or the need to please voters. Now, there's been a lot of discussion lately about diversity in the judiciary. Why is that considered so crucial? There are several reasons. Firstly, it's a matter of fairness and representation. The judiciary should reflect the society it serves. So having a bench that's more diverse in terms of gender, ethnicity, background, and experience, it's about making sure different perspectives are considered. It is not about making the courts look more diverse. It's about ensuring that different voices and experiences are actually shaping legal decisions. Diversity brings a whole range of benefits to the legal system. Different perspectives can lead to more robust legal reasoning and more nuanced decision-making. It can help avoid groupthink, and it can also help challenge any unconscious biases that might exist. So diversity isn't just about optics. It's about improving the quality of justice. It enhances the legitimacy, the fairness, and the overall effectiveness of the legal system. So we've talked about the courts and the judges. Now let's get into the actual legal process. Let us walk through how a typical civil case works in the English legal system. A civil case is basically a legal dispute between two or more parties, and the outcome usually involves some kind of financial compensation or other remedy. So we're talking about things like contract breaches, personal injury claims, property disputes, that sort of thing. It's about resolving disagreements between people or organizations. How does this process usually begin? Well, one party, called the claimant, files a claim against another party, called the defendant. So the claimant is the one who initiates the legal action. They set out their allegations against the defendant and what remedy they're seeking. And then what happens? The defendant gets a chance to respond. They can either admit liability, meaning they accept responsibility, or they can defend themselves against the allegations. So it's like a back and forth, each side presenting their case. And if they can't settle things through negotiation or mediation, then the case goes to trial. And that's where a judge or jury steps in. At trial, both sides present their evidence and arguments, and the judge or jury makes a decision based on what they hear. It sounds straightforward in theory, but it can get pretty complicated in practice, all the procedural rules and whatnot. It can be a real headache. So that's a glimpse into civil cases. What about criminal cases? A criminal case involves an alleged violation of criminal law. It's brought by the state, the prosecution, against an individual accused of a crime. So it's the state versus the individual. And unlike civil cases, which are mostly about compensation, criminal cases are about punishment. The state wants to hold the accused accountable for their actions. So the stakes are much higher, and the standard of proof is different too. In a criminal case, the prosecution has to prove the defendant's guilt beyond a reasonable doubt. You've heard that phrase. It's a very high standard, much higher than in a civil case. In a civil case, it's just the balance of probabilities. But in a criminal case, because we're talking about potentially taking away someone's liberty, the bar is set much higher. So how does a typical criminal case move through the system? It usually starts with an arrest by the police, followed by an investigation, gathering evidence, interviewing witnesses. And if the police think there's enough evidence, they pass it on to the Crown Prosecution Service. They're the ones who decide whether to actually take the case to court. So it's not automatic. They have to look at the evidence, the seriousness of the offense, and whether a prosecution is likely to be successful. So there's a filter there. It's not just about arresting someone. You have to make sure there's a good chance of getting a conviction. So let's say the CPS decides to go ahead with the prosecution. What happens next? Then the case is brought before a court, and the defendant is formally charged, right? At this point, the defendant has to enter a plea, meaning they have to say whether they're guilty or not guilty, and if they plead not guilty, then it goes to trial. That's the big showdown. Exactly. That's where the prosecution presents its case. The defense gets to challenge that evidence and present their own side of the story. And in criminal trials, juries play a big role. A jury is basically a group of ordinary people randomly selected from the community. They listen to all the evidence presented at trial, and then they decide whether the defendant is guilty or not guilty. So it's ordinary citizens who make that decision. That's it. It's a cornerstone of the English legal system. The idea is that justice should be decided by one's peers, not just by legal professionals. It's supposed to bring in a lay perspective. So what are the arguments for and against using juries in criminal trials? People who support the jury system argue that it brings in that common sense perspective. It makes sure verdicts are grounded in community values. They also say it helps safeguard against bias because it's a random group of people making the decision, not just a single judge. But I imagine there are concerns about juries too. Some people worry that juries can be swayed by emotion, especially in high-profile cases with lots of media coverage. They might get caught up in the drama. And there's also the concern that juries might not always understand complex legal arguments or technical evidence, and that could lead to mistakes. So it's a balancing act. It is weighing the benefits of having a jury against the potential risks. It's an ongoing debate with strong arguments on both sides. Remember, there are no juries in civil trials. Let's talk about something that no one wants to think about, but it does happen: miscarriages of justice. What happens when someone is wrongly convicted in the English legal system? Well, it's a terrible thing. It undermines trust in the whole system. But there are mechanisms in place to try to address these situations. One of the main avenues is through the Court of Appeal. So if someone believes they've been wrongly convicted, they can appeal to this court, and the Court of Appeal can review the evidence and the legal arguments to see if any errors were made. So it's like a second chance to get it right. It's a safeguard, a way to double-check things. But what if the Court of Appeal upholds the conviction? Are there any other options? There is another option, the Criminal Cases Review Commission. It's known as the CCRC. It's an independent body that investigates potential miscarriages of justice. So they look to cases where someone has already appealed. They've exhausted all the usual options, but there's new evidence, or maybe some compelling reasons to believe there's been a wrongful conviction. So it's a last resort for people who feel the system has failed them. And what can the CCRC actually do? Well, they can refer cases back to the Court of Appeal if they think there's a real possibility the conviction will be overturned. So it's a crucial safety net. It is recognizing that even the best legal systems can make mistakes. Let's move on to something that's been a big topic of discussion in legal circles, this whole debate over judicial activism versus judicial restraint. So judicial activism, it's basically the idea that judges should be willing to go beyond a strict, literal reading of the law. They should consider broader societal and political factors when making decisions. So they shouldn't just be robots blindly applying the rules. They should think about the context, the potential impact of their decisions. People who support judicial activism believe judges have a responsibility to protect individual rights, promote social justice, even push for social progress, even if that means kind of stretching the boundaries of legal interpretation. They're willing to be more proactive. And that's where judicial restraint comes in, as the counterpoint. Judicial restraint emphasizes that judges should be more cautious. They should defer to the legislature, the elected branch of government, so they should stick to the letter of the law. That's the idea. And avoid making decisions that seem like they're legislating from the bench. The argument here is that it's about maintaining the separation of powers, not overstepping those boundaries. People who favor judicial restraint believe judges should focus on interpreting the law as it is, not trying to create new law. So it's a debate about the role of judges, how active they should be in shaping the law. It's a complex issue with valid arguments on both sides. Let's shift our focus to lawyers. What's their role in the English legal system, and why are they so important? Well, I'd say lawyers are essential for ensuring access to justice and upholding the rule of law. You know, for most people, the legal system is just this confusing maze. It can be intimidating. Lawyers are the ones who guide people through that maze. They make sure people's rights are protected. They act as translators, making the law understandable. They explain things clearly, advise clients on their rights, and represent them in court. Without lawyers, the whole system would be inaccessible for most people. It would be a system where only the wealthy could really get justice. Now, we talked earlier about the different types of lawyers, solicitors and barristers. We can now delve a bit deeper into their specific roles. So solicitors, they're usually the first point of contact. They handle a wide range of legal matters, from drafting contracts to advising on property transactions, family law, and business disputes. So they're like the general practitioners of the legal world. They deal with the everyday legal needs of people and businesses. They provide guidance, draft documents, and represent clients in some court proceedings. But if a case needs more specialized advocacy, that's when barristers come in. They're the courtroom specialists. They focus on arguing cases before judges and juries. They're the ones who deliver those dramatic closing arguments we see in movies. So it's a division of labor. Solicitors do the groundwork. Barristers handle the courtroom battles. That's the traditional model. Although we mentioned earlier that those lines are blurring a bit, we're seeing more solicitor advocates now. They can argue cases in court too. The profession is adapting. There have been some changes to how solicitors and barristers are regulated. Traditionally, solicitors were regulated by the Law Society and barristers by the Bar Council. But then the Legal Services Act of 2007 came along and shook things up a bit. It revamped the specialized regulators for solicitors and affected the one for barristers. The solicitor's regulator is now called the Solicitors Regulation Authority, or SRA. The Bar Standards Board, on the other hand, regulates barristers and specialized legal services businesses in England and Wales in the public interest. The idea was to clarify things, to make the rules more consistent and encourage competition in the legal services market. Now, let's talk about something I think is really important: legal ethics, a crucial topic. Lawyers have a huge responsibility. They deal with sensitive information. Their decisions can have a big impact on people's lives. So what are some of the key ethical principles that guide their work? Well, legal ethics is all about ensuring that lawyers act with integrity, honesty, and in their clients' best interests. But they also have duties to the court, to the administration of justice. So it's a balancing act. It can be tricky sometimes. It's not just about winning at all costs. There are bigger ethical considerations at play. So what are some of those core principles? Well, some of the big ones are confidentiality, loyalty, honesty, and integrity. Confidentiality means lawyers have to keep their clients' information private. What's said between a lawyer and their client stays there. It's about building trust, making sure clients feel comfortable sharing everything. What about loyalty? Loyalty means lawyers have to put their clients' interests first. They can't act for someone else if there's a conflict of interest. Double dealing and dishonesty are not allowed. Honesty and integrity are pretty self-explanatory. Lawyers have to be truthful with the court, with other lawyers, and with their clients. No misleading anyone. Violating these principles can have serious consequences: disciplinary action, fines, suspension, even being disbarred. So they don't mess around. Legal ethics is taken very seriously. We've talked a lot about the traditional aspects of the English legal system, but I also want to touch on something that's changing the game. Technology is transforming every aspect of our lives, and the legal world is no exception. Definitely, we're seeing a lot of changes. So how is technology changing the way the English legal system operates? One of the biggest changes is electronic filing of court documents. Many courts now allow you to file things electronically, so no more mountains of paper. That's the idea. Saves time, money, and hassle. Makes sense. And what about hearings and trials? We're also seeing more video conferencing being used. People can participate remotely, so virtual courtrooms are becoming a thing. And it's great for people who can't easily travel to court. Accessibility is a big issue, and video conferencing can help with that. Also, artificial intelligence is making waves in lots of fields, including law. How is AI being used in the English legal system? Well, one of the main areas is legal research and document review. Imagine having to go through tons of documents to find the relevant info for a case. AI can analyze huge amounts of data, identify patterns, and pull out the key information. So it's like a superpowered research assistant. It can save lawyers a lot of time and effort. But there are also concerns about using AI in this way. One big worry is bias. If the data used to train an AI system is biased, then the system itself can be biased. And that could lead to unfair outcomes. It's a real concern. So we need to make sure that AI systems are developed and used responsibly. Fairness is paramount. And then there's the bigger question of, can an algorithm really replace human judgment? Especially when it comes to legal decisions that affect people's lives. That's a big one, and it's something we need to think carefully about. We've covered a lot of ground today, from the history of common law to the impact of technology. It's clear that the English legal system is complex and constantly changing. So as we look ahead, what are some of the key challenges facing the system? I think one of the biggest challenges is ensuring access to justice for everyone. Those legal aid cuts have made it really difficult for some people to afford legal representation. So finding ways to make legal help more affordable and accessible, that's crucial. And what about technology? Keeping up with the rapid pace of technological change is another topic. It's moving so fast, and the system needs to adapt to embrace the benefits while also addressing the ethical concerns. It's about finding that balance. And then there's this ongoing debate about the role of the judiciary. How do we balance independence with accountability? That's a key question. And how do we maintain public trust in the system? All important issues. So it's not just about the laws themselves, but about the people who apply those laws. It's about the institutions, the processes, the whole framework. It's a fascinating, complex world. I leave you with a question to ponder. What role do you think the law should play in our society? How can we make sure the English legal system continues to uphold those values of fairness, justice, and the rule of law in a world that's constantly changing? It's a challenge, but an important one. It is, and it's something we all have a role to play in. If you enjoyed this video, subscribe to the channel for more. See you next time.